Welcome to the Deep Dive. Today, we're diving headfirst into a topic that affects every single one of us, whether we realize it or not. U.S. federal tax law.
That's right.
We've got a whole stack of sources that really dig into the nitty-gritty of tax rules, the role of the IRS, and, well, the vital professionals who can help you navigate it all.
And our mission today really is to pull back the curtain on this often complex system. We wanted to demystify it for you.
Okay.
We'll explore where tax law actually comes from, differentiate the IRS's role as, an enforcer versus a lawmaker, clarify the real authority behind different IRS documents.
Which is so important.
It really is. And maybe most importantly, break down exactly who can practice before the IRS and what that truly entails.
It's such a fascinating landscape of rules and roles, and I think by the end of this deep dive, you'll have a much clearer picture of how the system works, how to understand its nuances, and, how to effectively navigate it for yourself.
Let's do it.
So let's unpack this. To really get this, we need to start right at the foundation. Where does U.S. Really?
Well, the IRC, which is Title 26 of the United States Code, is definitely the primary body of U.S. tax law. Congress enacts it. It's basically the blueprint for our entire federal tax system.
The main blueprint, yeah.
But here's where it gets really interesting. Not all tax law is just in Title 26.
Ah, okay. I've always wondered about that. Like, how do these other laws, state community property laws, for instance, actually intersect with federal tax rules?
That's a great question. So while the IRC is central, other tax laws can come from states, cities, even municipalities.
Right.
For instance, the state-specific community property laws. They directly influence how spouses report income on separate federal tax returns. It's a direct impact. And we also see things like the Bank Secrecy Act, which is actually in Title 31, not 26. That's the source for FBAR's foreign bank and financial accounts and most other international financial reporting laws.
Title 31. Okay, so a completely different part of the U.S. Code.
Exactly. And what's really illuminating here is that FinCEN, the Financial Crimes and Enforcement Network, they actually delegated the enforcement authority for FBRs to the IRS back in 2003.
Oh, interesting. So FinCEN made the rule, but the IRS enforces it.
Precisely. And that delegation shows that tax law isn't just some static book of rules from Congress. It's a living system, constantly being shaped by different government bodies.
Which means you, the listener, really need to stay nimble, right? You can't just assume things work the same way they always have.
Absolutely. It highlights that federal tax law is dynamic, influenced by all three branches of government, not just Congress writing the code.
Okay, so if Congress makes these, let's say, broad strokes of the law in the IRC, what exactly is the IRS's role? We hear about them constantly, but are they lawmakers or are they something else?
That's the crucial distinction, really. The IRS is the federal agency that enforces tax law. You can think of them as the collection arm for the U.S. Treasury Department.
The enforcement.
Right. But, and this is key, they do not enact tax law themselves. That's Congress's job. What the IRS does is translate those congressional laws, the Internal Revenue Code, into detailed regulations, rules, procedures.
Okay.
Which they then administer. So they interpret, they administer, but they don't legislate. They're sort of like the team that takes the recipe from the chef, Congress, and figures out all the precise steps to actually bake the cake.
Gotcha. And when we talk about these interpretations and rules, it leads us straight to this idea of authority in tax law. It sounds like not all guidance is created equal, not by a long shot.
Absolutely not. It's critical to understand a hierarchy. The highest sources of guidance are what we call primary authority.
Primary authority.
Yes. This includes the Internal Revenue Code itself, decisions from the U.S. Supreme Court, and international tax treaties. That's the top tier.
Bedrock.
Exactly. Then you have what's called substantial authority. This also includes things like temporary and final regulations, other court cases, administrative pronouncements, and even congressional intent, which you often find in committee reports explaining the law.
Okay, substantial authority. Still pretty weighty stuff.
Very weighty. But now, for you, our listener, here's a really vital insight. Imagine you carefully follow an IRS publication, or maybe the instructions on an IRS form.
Yeah, like Publication 17, the general guide.
Right, exactly. You follow it to the letter, but then you find yourself facing a penalty because those instructions weren't actually legally binding in that way.
Ouch.
That's the critical difference. Official IRS publications and the instructions on IRS forms are not considered substantial authority.
Not substantial authority. Wow.
Relying solely on them won't protect you from understatement penalties, often because, well, many of these documents aren't updated every single year, or they're just meant to be informational guides, not the final legal word.
That's a huge point. So for the listener, what's the biggest risk if they rely solely on, say, Publication 17? What could actually happen?
The biggest risk is getting hit with accuracy-related penalties. While those publications are generally helpful and usually accurate, they are interpretations, not the law itself.
Right.
So if you take a tax position based only on a publication, and it turns out that position isn't supported by the code or regulations or other substantial authority, well, you could be on the hook for penalties. You really need to look to the actual law or those other high authority sources.
But I understand there's been a recent change regarding FAQs, the frequently asked questions on the IRS website. It sounds like maybe there's a shift in how much weight they carry now.
Yes, that's a good point. There is an important update that gives a bit more, let's say, formal backing to some of that online guidance.
Okay.
The IRS announced that any future FAQs posted on ars.gov will now be issued as fact sheets via IRS press releases.
So a different format.
A different format. And that subtle but significant change means these new FAQs can actually constitute authority for taking a tax return position. It's a move to give them a bit more formal standing than they had before.
Okay, that's definitely something to watch. So, with that foundation laid, let's pivot to decoding these various IRS documents and guidance types. Treasury regulations. They sound pretty official, like maybe the most official interpretation.
They are indeed the U.S. Treasury Department's official interpretations of the Internal Revenue Code. Think of the IRC as, the broad strokes of the law.
The framework.
Right. And Treasury regulations are the detailed fine print blueprint that tells us how to actually build what Congress envisioned. They're meticulously written by the IRS Office of Chief Counsel.
Okay.
And they have to be approved by the U.S. Treasury Secretary.
Right.
Once approved, they're published in the Federal Register, and then they get codified into the Code of Federal Regulations. Courts generally give them a lot of weight. They uphold them as long as they're reasonable and don't directly contradict the statute, the IRC itself.
And there are different kinds of these regulations too, right? It seems like they might have varying degrees of legal weight depending on how they came about.
Correct. We generally categorize them into three types based on their origin. First, you have legislative regulations.
Legislative.
These are created when Congress explicitly delegates authority to the Treasury Secretary or the IRS Commissioner to provide specific requirements for a particular part of the code.
So Congress actually says, you guys write the details for this section.
Exactly. You fill in the blanks here. So these are powerful, often carrying pretty much the same authority as the law itself. But they can still be overturned by courts if they go beyond that delegated power, if they conflict with the statute, or if a court just deems them unreasonable.
Okay, so even the strongest ones aren't completely unchallengeable.
Right. Second are interpretive regulations. These are issued under the IRS's general authority to interpret the IRC. They basically just explain the meaning of a code section.
So less direct delegation from Congress.
Correct. There's no specific grant of authority for their creation, unlike legislative regs. So they can be challenged more easily if they don't seem to truly reflect what Congress intended.
Makes sense.
And finally, you have procedural regulations. These deal with the administrative side of things, the how-to of the code. They're typically issued by the IRS Commissioner, not the Treasury Secretary, and often cover, minor issues like notice timings or how to file certain forms, the everyday operational details.
Okay, so legislative, interpretive, procedural, ranging from nearly law-level authority down to administrative details. How do we know their current status? Like, are they still just drafts, or are they fully locked in?
Good question. That's where their classification by status comes in. You have proposed regulations, which are put out there for public commentary, allows people to give feedback before they become final.
Okay, the feedback stage.
Then you have temporary regulations. These are effective immediately when they're published, and they provide immediate guidance, usually for up to 3 years. They kind of bridge the gap until a final regulation is ready.
So quick guidance when needed.
Exactly. And finally, you have final regulations. These are the official Treasury decisions. They're also effective immediately upon publication, and they hold the highest authority from the Treasury Department. They essentially have the force of law.
Wow.
And what's really fascinating here is how this whole process, from proposed to temporary to final, reflects this really meticulous system of legal interpretation and public engagement before something carries the full weight of law. It's designed for precision, even if it feels, well, a bit complex sometimes.
Definitely complex, but you can see the logic. Okay, moving beyond regulations, we also hear about revenue rulings and revenue procedures. How do these fit into this whole puzzle of IRS guidance?
Right, so revenue rulings and revenue procedures are issued by the IRS National Office. Their goal is to inform and guide taxpayers. A revenue ruling typically states the IRS's official position on how a specific tax law applies to a particular set of facts.
Like an example scenario.
Pretty much. For instance, Revenue Ruling 2024-1 would be the first official ruling issued in the year 2024. Now, importantly, they're not strictly binding in tax court or other U.S. courts,
Oh, okay.
but taxpayers can use them as guidance to help avoid certain accuracy-related IRS penalties. So they offer some protection.
So helpful, but not quite law.
Correct. Revenue procedures, on the other hand, provide instructions concerning an IRS position. They detail the steps for taxpayers or sometimes IRS employees to take. So you can think of rulings as what the IRS thinks about Situation X and procedures as here's how you do process Y with the IRS.
Got it. Rulings are the what, procedures are the how. What about even more specific guidance, say, for individual taxpayers or unique transactions? Like if you've already filed your return and an auditor brings up a really tricky question, or maybe you're planning a complex business deal and want to know the tax hit before you pull the trigger. Is there anything for that?
Yes, absolutely. That's where technical advice memoranda, or TAMs and private letter rulings, PLRs, come into play.
TAMs and PLRs.
Right. A TAM is written guidance from the IRS Office of Chief Counsel. It's issued at an IRS director's request, usually for technical or procedural questions that pop up during an examination, a refund claim, or maybe an appeal.
So it comes from within the IRS, usually during an active case?
Exactly. And a key point here, TAMs are issued only on closed transactions, things that have already happened. They provide the IRS's interpretation of tax laws and treaties as applied to a past event.
Okay, dealing with the past. What about planning for the future, those complex deals?
That's where private letter rulings, or PLRs, are useful. A taxpayer can specifically request an IRS interpretation for their unique situation before a transaction is completed or a tax return is filed.
Ah, proactive guidance.
Very proactive. And a PLR is legally binding on the IRS, but only for that specific taxpayer who requested it, and only if the transaction was described accurately in the request and then carried out exactly as described.
Okay, very specific conditions.
Yeah, be aware, these are definitely not free. The minimum user fee often starts at $10,000, sometimes much more.
$10,000. Wow.
Yeah, so this isn't for, clarifying if you can deduct your home office expenses for your side gig.
Right.
This is typically for major corporate reorganizations, multi-million-dollar deals where the tax implications are huge and certainty is paramount. It really shows the level of complexity and the amount of money that can be involved at that level.
Definitely underscores the stakes.
Okay, beyond those really specific rulings, we also have things like the Internal Revenue Manual, the IRM, and just standard IRS forms and publications. Where do they stand in terms of authority? Are they gospel? Should we treat them like law?
Good question. The Internal Revenue Manual, or IRM, is the official compilation of IRS policies, procedures, guidelines. But it's primarily for IRS employees.
Ah, it's their internal playbook.
Exactly. It tells IRS agents how to do their jobs. While it is public information, you can find it on the IRS website, it's essentially an employee handbook. It is not considered primary or substantial authority for taxpayers.
Okay, so helpful to see how they operate, but not something you rely on for your tax position. Correct. Similarly, IRS forms and publications, like the Publication 17 we mentioned, are designed to disseminate information and explain the law in hopefully simpler terms.
Yeah, they try.
They are drawn from primary authority, definitely, but the publications themselves lack substantial authority. You cannot rely on them solely to avoid accuracy-related penalties. They're for informational purposes, not for legal reliance.
That distinction just keeps coming up. Informational versus authoritative.
Right.
Crucial. Okay, we've talked a lot about what the IRS publishes, but what about the information the IRS holds? About us, the taxpayers? That often comes up when we think about things like the Freedom of Information Act, right?
Exactly. Sometimes you just need to know what information the IRS actually has on you or on a particular issue. That's where the Freedom of Information Act, FOIA, comes in.
FOIA.
It's a really powerful tool that basically says the government's records are, in principle, public records, with some important exceptions, of course.
Right, there are always exceptions.
Always. The IRS generally has 20 business days to respond to FOIA requests, but they can withhold information under specific exemptions, things protecting national security, individual privacy, maybe proprietary business information, or sensitive law enforcement records.
Makes sense.
And it's worth noting, there are even specific types of FOIA requests that are tailored for tax preparers trying to get information for their clients.
Interesting. Okay, so we've navigated the maze of rules and documents, but who is they enforce the rules? Let's pull back the curtain a bit on the IRS's own structure, and critically, who can actually step in and speak for you when dealing with them?
That's a great area to cover. The IRS is a huge organization, and it's structured into 4 main operating divisions, each serving pretty distinct taxpayer segments.
Their divisions. Okay.
First, you have Large Business and International, or LBNI. As the name suggests, it focuses on corporations and partnerships with assets over $10 million. They're the ones typically auditing large, publicly traded companies.
The big guys.
The big guys. Then there's a Small Business Self-Employed Division, or SBSE. This covers smaller corporations and partnerships, those under $10 million in assets, plus filers of gift, estate, excise, employment, and fiduciary returns, and importantly, individuals with business or rental income reported on Schedule C, E, or F.
So a lot of small business owners, landlords, gig workers would fall under SBSE.
Exactly. And understanding these divisions isn't just trivia. It really helps you navigate the system. Like you said, if you're a gig worker with a Schedule C, you'll likely deal with SBSE. And they have a very different approach and, frankly, different priorities than LB&I auditors looking at multinational corporations.
Right. What about the other 2 divisions?
The third is the Wage and Investment Division, or W&I. This serves individuals who only have wage and investment income. So no international returns, no Schedule C, E, or F. This is probably where most individual listeners, just earning a salary and maybe some dividends, would fall.
Okay. The most common individual filers.
Likely, yes. And finally, there's the Tax-Exempt and Government Entities Division, or TG. This handles employee retirement plans, including IRAs, actual exempt organizations like charities, and various government entities.
Got it. LBNI, SBSE, WNI, and TG. And if you run into problems, say you feel stuck or unfairly treated, beyond just knowing which division handles your type of return, there's also the Taxpayer Advocate Service. What exactly do they do?
Yes, the Taxpayer Advocate Service, TAS, is an incredibly valuable resource. It's designed to be an independent organization within the IRS.
Independent within the IRS, okay.
Yeah, it sounds a bit odd, but they act as a voice for the taxpayer. They offer free and confidential assistance. You're generally eligible for TAS help if you're facing significant economic harm because of an IRS action, or maybe if you're just experiencing major delays in resolving a tax issue and hitting dead ends.
So they can help cut through red tape.
That's a great way to put it. They can cut through red tape when you feel really stuck. The quickest way to contact them is often by fax, believe it or not, or you can submit a specific form, Form 911, Request for Taxpayer Advocate Service Assistance.
Form 911. Easy to remember. Okay, let's get to the absolute heart of representation. What does it actually mean to practice before the IRS? It sounds like it's got to be more than just helping someone fill out their 1040 form.
Oh, absolutely. Practice before the IRS is a broad term, legally defined. It basically encompasses all matters connected with a presentation to the IRS or anything relating to a taxpayer's rights, privileges, or liabilities under the laws and regulations the IRS administers.
So any interaction about rights and liabilities.
Pretty much. This includes corresponding and communicating with the IRS, representing a taxpayer at conferences, hearings, or meetings, preparing and filing necessary documents related to those interactions, and even providing written advice if that advice has the potential for tax avoidance or evasion.
Interesting. And I think you mentioned earlier U.S. citizenship isn't required.
That's correct.
Yeah.
It's a common misconception, but U.S. citizenship is not required to practice before the IRS.
Okay, but what's really key here, I think, are the exclusions. What is not considered practicing before the IRS? This feels like a critical distinction for people to grasp.
This is absolutely vital, and yet trips a lot of people up. Practice before the IRS does not include representation before the U.S. tax court.
Okay. Tax court is separate.
Completely separate rules, separate admission requirements. It also doesn't include merely appearing as a witness for a taxpayer. Witnesses provide facts. They don't advocate for the taxpayer's position.
Right. Different roles.
And perhaps the most crucial exclusion, the one that surprises many. Simply preparing a tax return does not, by itself, constitute practice before the IRS.
Wow. So your regular tax preparer, just by doing your return, isn't practicing before the IRS?
Correct. They assist in return preparation, absolutely. But that act alone doesn't grant them the right to represent you in, say, an audit of that return or handle appeals or other complex matters beyond that specific filing.
So practice is really about the advocacy piece, the direct interaction on legal or procedural matters.
Exactly. It's about advocacy, representation in disputes, negotiating liabilities, things like that. Not just the mechanical act of filling out the forms based on the information the taxpayer provides.
Okay, that clarifies a lot. So if just preparing a return isn't practice, who does have the unlimited right to practice before the IRS? Who are the real heavy hitters allowed to represent taxpayers on any issue?
There are only 3 groups who have unlimited rights to represent taxpayers before any IRS office and on any tax matter. These are attorneys, certified public accountants, CPAs, and enrolled agents.
EAs, attorneys, CPAs, EAs, the big 3.
Those are your fully authorized representatives for basically anything IRS related.
Yeah.
Now, there are also a couple of other enrolled practitioners with limited rights, enrolled actuaries, and enrolled retirement plan agents. Their practice is very specifically focused on employee retirement plans.
Okay, specialized roles. And who oversees all these practitioners? Make sure they're following the rules.
Good question. There are 2 key offices within the IRS for that. The Office of Professional Responsibility, or OPR, is responsible for practitioner conduct, handling discipline, and imposing sanctions if necessary. They're like the ethics police for tax pros.
OPR, okay.
And then there's the Return Preparer Office, or RPO. They handle the more administrative side, issuing Preparer Tax Identification Numbers, PTINs, processing enrollment applications for EAs and others, and administering programs like the AFSP, the Annual Filing Season Program.
Ah, yes, the AFFP. Let's talk about that. That's the annual filing season program for unenrolled preparers, right? The ones who aren't attorneys, CPAs, or EAs. It's voluntary, designed to encourage a certain level of competence.
Exactly. It's a voluntary program, kind of replaced the old RTRP program that got shut down. It's aimed at encouraging competence and ethical behavior among tax preparers who aren't one of the big 3.
So how does a preparer get this AFSP recognition?
To receive what's called a record of completion for the AFSP, an unenrolled preparer generally needs to complete 18 hours of continuing education, CE, within the calendar year.
18 hours?
Yes, and that has to include a specific 6-hour course called the Annual Federal Tax Refresher, or AFTR, which includes a test. They also need a current PTIN, of course, and they have to formally consent to the duties and restrictions laid out in Treasury Department's Circular 230, which governs practice before the IRS.
Circular 230? That sounds important.
It's the rulebook for practitioners. So the AFSP is basically a way for these unenrolled preparers to demonstrate they've kept up to date with tax law changes and understand their ethical obligations.
Are there any exemptions from that main refresher course, the AFTR? And more importantly, what exactly are their practice rights once they complete the AFSP? How much can they actually do for a client with the IRS?
Yes, there are exemptions from the APR course itself, though
Yeah.
not the other requirements like the PTIN and Circular 230 consent. Certain individuals can get the AFSP record of completion without taking the 6-hour course and test if they complete 15 hours of other qualifying CE, including ethics and federal tax law.
Who qualifies for that exemption?
It includes preparers who participate in certain state-based preparer regulation programs, like in Oregon or California. Also, folks who've recently passed Part 1 of the Special Enrollment Exam for EAs, certain volunteers in the VITA or TCE programs, and holders of some other specific accredited tax credentials.
Okay, so some recognized alternatives. But what about the practice rights? Even with that AFSP certificate, how far can they go?
This is the crucial limitation. Even with a current AFSP record of completion, unenrolled preparers have very limited practice rights. They can only represent taxpayers during an IRS examination, an audit, and only for the specific tax year or period of the return they themselves prepared and signed.
Ah, only for the return they actually did.
Exactly. They cannot represent taxpayers before IRS appeals officers, they can't execute closing agreements, they can't grant extensions for statutory assessment periods, and they can't sign documents on behalf of a taxpayer using a power of attorney.
So if you're audited on a return they prepared, they can talk to the auditor for you. But if that audit goes badly and you need to appeal it,
They can't represent you in the appeal. You'd need an attorney, CPA, or EA for that level.
that's a really significant limitation to understand. Okay, so even if you don't fall into one of those credentialed categories like attorney, CPA, EA, or even AFSP holder, There are still specific situations where you might be able to represent someone simply because of a special relationship, right? Like, if your spouse gets an audit notice, you, as their spouse, could potentially represent them without needing any special license.
That's correct. There are provisions for representation based on specific relationships. An individual can always represent themselves, obviously.
Right, pro se.
Yes. And beyond that, an individual can represent immediate family members. The rules define that as a spouse, child, parent, brother, or sister. It's based on that close, direct, established relationship.
Okay, immediate family. What about businesses or organizations?
For organizations, a bona fide officer can represent their corporation, association, or organized group. Similarly, a general partner can represent the partnership they're a partner in.
Makes sense. Someone in charge.
And a regular employee can represent their employer. But that doesn't mean just any employee can walk in. It generally has to be someone whose duties might reasonably include handling such matters.
Not the janitor, probably.
Probably not, unless their job description is very unusual. Also, a fiduciary, like a trustee of a trust or an executor of an estate, is actually considered the taxpayer themselves for representation purposes.
Yeah.
Not technically a representative acting for someone else.
Ah, they step into the taxpayer's shoes.
Precisely. And in very rare cases, the IRS commissioner can authorize special appearances for individuals who would otherwise be ineligible. But this is uncommon, and usually for very specific, limited situations.
Good to know those exceptions exist. And you mentioned something important earlier, too. A corporation or a partnership itself can't practice, right? It always has to be an individual human being named as the representative.
Absolutely critical point. Corporations, associations, partnerships, they are not eligible to practice before the IRS. An individual must be named on the power of attorney or other authorization. And even if an individual is named, if they themselves are ineligible to practice, maybe they've been suspended by the OPR, they still can't represent the taxpayer, even with that power of attorney.
The individual practitioner status is key. Okay, that brings us nicely to how one actually becomes one of those top-tier representatives, specifically an enrolled agent or EA. It sounds like the very first essential step for anyone preparing taxes for a fee, regardless of credential, is getting a PTIN.
That's absolutely right. The PTIN, the Preparer Tax Identification Number, is mandatory. It's a 9-digit number. Anyone who prepares or assists in preparing federal tax returns or claims for refund for compensation must have a PTIN and must include it on the returns they prepare.
For compensation, that seems key.
It is. This includes enrolled agents and also many attorneys and CPAs if they are preparing returns for pay. If you're getting paid to prepare and sign a federal return, you generally need a PTIN.
So what exactly determines if you're a paid preparer who needs a PTIN? Is it just about receiving cash? What if someone gives you a gift card or does you a favor in return?
The regulations look for an agreement for compensation. If an individual prepares the tax return with no agreement for compensation, explicit or implicit, they typically aren't considered a tax return preparer who needs a PTIN for that return, even if they happen to receive a gift or a favor later on.
The agreement is the deciding factor.
Generally, yes. You also don't need a PTIN if you're just, say, giving an opinion by hypothetical events, not a specific return. Or if you're only providing typing or copying services, or preparing your own employer's return as a regular employee, or acting as a fiduciary for a trust or estate, or if you're an unpaid volunteer under programs like VITA or TCE.
Via TCE, volunteers don't need one.
Correct, because they're not compensated. IRS employees performing their official duties are also exempt. It really hinges on that formal or informal agreement for compensation for the preparation service itself.
Okay, that makes sense. So assuming you have your PTIN, how does one actually become an enrolled agent? What are the pathways to earning that specific credential?
There are really two main pathways to becoming an EA. The most common route is by passing all 3 parts of the Special Enrollment Exam, the C.
The EA exam.
Exactly. It covers individual taxes, business taxes, and representation, practice, and procedures. After successfully passing all 3 parts, you then file Form 23, which is the application for enrollment to practice before the IRS. And critically, you must pass a thorough IRS background check, looking into your own tax compliance history and general fitness.
Okay, exam plus background check. What's the second path?
The second track is for certain former IRS employees. Individuals who have a minimum of 5 years of past service with the IRS in a qualifying technical position, as specifically outlined in Circular 230.
5 years at the IRS in the right role.
Yes. They can apply for enrollment based on that experience. They must apply within 3 years of leaving the IRS. They also have to file Form 23, and they also must pass that same background check. So either demonstrate knowledge through the exam or demonstrate it through qualifying IRS experience.
Both routes require proving suitability through the background check. What could lead to a denial of enrollment? It sounds like that they take that ethical standing and tax compliance part very seriously.
They absolutely do. The IRS can deny enrollment for various reasons related to conduct.
Yeah.
Any finding of disreputable conduct, which is broadly defined in Circular 230, or certain criminal convictions, can be grounds for denial.
Okay.
And perhaps more commonly, simply failing to timely file your own federal tax returns or failing to pay your own taxes can be grounds for the Return Preparer Office, the RPO, to deny an application. You have to demonstrate integrity and compliance yourself.
Practice what you preach, essentially.
Exactly. If an application is denied, the RPO has to inform the applicant of the reason in writing, and the applicant then has 30 days to file a written appeal of that decision.
Okay, there's an appeal process. So once you successfully navigate all that and become an EA, how do you maintain that status? This isn't a one-and-done kind of certification, is it? It sounds like there's a continuous commitment required to stay updated and ethical.
Oh, far from one and done. Being an EA requires ongoing commitment. EAs must renew their enrollment every 3 years.
Every 3 years.
Yes, and it's done during specific renewal windows, typically running from November 1st to January 31st, just before the new 3-year cycle starts on April 1st. Your specific renewal schedule is actually determined by the last digit of your Social Security number.
Oh, really? They spread it out?
Yeah, they cycle through SSN ending 03, then 46, then 79 over the 3 years. For foreign preparers without an SSN, they use the 789 renewal schedule. And as part of this renewal process, the IRS actually verifies your own tax filing and payment history again.
They check every time you renew. Wow.
Yes. You have to remain compliant yourself to keep the credential. And of course, there's continuing education.
Right, the CE. How much is required to keep that EA status active?
During each 3-year enrollment cycle, an EA must complete a total of 72 hours of continuing education credit from IRS-approved providers.
72 hours over 3 years.
Yes, but critically, there's an annual minimum. A minimum of 16 hours of CE must be completed each enrollment year. And within that 16 hours per year, at least 2 hours must be dedicated specifically to ethics or professional conduct.
16 hours minimum per year, with 2 hours of ethics baked in.
Okay. This structure ensures continuous learning and reinforcement of ethical standards year after year. Now, there's a slightly different special rule for brand new EAs during their very first enrollment cycle.
Oh, what's different for them?
Because their first cycle might be shorter than a full 3 years, depending on when they enrolled. They have a prorated requirement. They need to complete 2 hours of CE for every single month they are enrolled during that initial cycle.
2 hours per month, that could add up quickly.
It can, and importantly, they still have to complete the 2 hours of ethics annually during that initial period. There's no exception or proration for the ethics requirement. Once their first full 3-year cycle begins after that initial period, they then revert to the standard 72-hour, total 16-hour annual minimum requirement like everyone else.
Wow, that's a significant commitment, especially right at the start. But I guess it ensures EAs really stay on top of their game and remain incredibly knowledgeable and accountable from day one.
That's precisely the goal. It maintains the high standard associated with the enrolled agent credential.
What an incredible deep dive into this labyrinth of federal tax law, the IRS, and the vital roles of tax practitioners. Seriously, from the legislative power of Congress down to the detailed interpretive guidance from the IRS, and then these really stringent requirements for the professionals. It's so clear this system is built on layers upon layers of authority and accountability.
Indeed it is. And understanding these distinctions, we talked about, what constitutes primary authority versus just helpful publication guidance, or knowing who can actually represent you versus who simply prepares your return, that provides such a crucial foundation for any taxpayer.
Yeah.
It really highlights the specialized knowledge that's required to navigate the system effectively and hopefully empowers you, the listener, with some critical insights.
Absolutely. So what does this all really mean for you, our listener? When you step back and consider the sheer complexity we've discussed today and the fact that even seemingly minor guidance from the IRS can carry real legal weight, or that representation rights are so specifically defined, how does knowing about this intricate structure maybe change your approach to your own tax obligations? And maybe more pointedly, what level of responsibility does that ultimately place on those you might choose to guide you through this system?
That's the core question, isn't it? Who do you trust, and what level of authority do they truly hold?
Exactly. Exactly. Lots to think about there. We encourage you to keep exploring, keep questioning, and as always, keep diving deep.